The LRC was in the Constitutional Court today representing amaBhungane Centre for Investigative Journalism in the constitutional challenge to the Public Procurement Act. Today, we were able to make our submissions regarding the inadequacy of the public participation process accompanying the adoption of the Public Procurement Act. Public participation is a fundamentally important part of our legislative process in South Africa. Entrenched in the Constitution is an expectation that National Assembly, the National Council of Provinces, facilitates public participation when adopting any legislation. This is in order to give the public an opportunity to make submissions on draft legislation and have their voices heard in the legislative process. Parliament is obliged to facilitate meaningful and reasonable public participation. There is an obligation on Parliament to ensure that the public is given an opportunity to make submissions that ultimately can reach the minds of lawmakers and have a reasonable opportunity to influence the legislative process. What we saw with the Public Procurement Act was the exact opposite of this. Most of the submissions received by the National Assembly went unconsidered. The National Council of Provinces also fundamentally failed to engage with many submissions put in front of it. And throughout the whole process, both bodies of Parliament acted under incredibly truncated timeframes that prevented both them and the National Treasury, who played an important implementing role in the public participation process, from truly engaging with the submissions made by the public. Not only that, but the legislation fundamentally changed in a very material way during the process. And Parliament failed to ensure that the broader public was subsequently given the opportunity to comment on substantively and materially different versions of the legislation. All in all, this amounted to a clear inability for Parliament to turn around and say that they genuinely considered the submissions made by the public in front of them. It meant that the public participation process that accompanied one of the most fundamentally important pieces of modern day legislation in South Africa was constitutionally defective. Public participation is not just a tick box exercise. It's something that's supposed to exist to allow the public to have meaningful input when it comes to the drafting of legislation. The more important a piece of legislation is, the higher the standard or the higher the threshold is for the public participation process. When legislation is as important as the Public Procurement Act is, when legislation has as broad an impact as the Public Procurement Act does, Parliament is obliged to ensure that it provides ample opportunity to the public to make submissions on the legislation, and also ensure that there is enough time for the public to engage with the Act and make their submissions, and also for Parliament itself to engage with those submissions and reflect on their contents. Public participation is at the heart of our democratic system, and fundamentally so is public procurement. Public procurement is a process that allows the government to procure goods and services that are used across every single facet of service delivery. Public procurement may sound technical and may sound abstract and removed from many people's everyday lives, but it is the effective driver for service delivery in South Africa. Government is incapable of providing socioeconomic goods and services without effective public procurement. There is no piece of legislation that will have a greater impact on service delivery in South Africa currently than the Public Procurement Act. Not just that, but public procurement is a site within government expenditure that often sees a lot of wasteful expenditure, irregular expenditure, and the leakage of billions out of the public fiscus. It's fundamentally important to make sure that the process through which the government spends its money is well managed to safeguard against corruption and also to safeguard against ineffective expenditure and making sure that the government utilizes its resources effectively. I don't think there is anything else that can really demonstrate how important this legislation was. amaBhungane's central concern here was that the public participation process that accompanied the Act did not give effect, or rather did not acknowledge just how important this legislation was. Defects in the public participation process here were plentiful. And ultimately what that meant is Parliament never discharged their constitutional obligation. And the real cost of that is that the public was isolated from the legislative process here. They weren't given an opportunity to make submissions that meaningfully impacted the process. And the result is a piece of legislation that really does not reflect public perceptions, does not reflect public viewpoints, does not reflect the public democratic process that is supposed to underpin the legislative process in South Africa. Judgment was reserved after today's hearing, and we'll wait to hear what the Constitutional Court has to say about the submissions made by amaBhungane, but it's safe to say that we think they've got a pretty good case.